Fani Willis threatened by Congress with contempt. Jim Jordan on the Judiciary Committee has had enough of Fani's noise, right? She's been making a lot of hot air coming out and gas, and it's just enough already. Congress has sent a subpoena, and now he's threatening to hold her in contempt because she's not complying with the subpoena. And so Big Fani's in trouble. And we have a great report from this account on X saying that Fani's probably not going to be able to file those charges that got dismissed a second time, because that's going to delay the case basically indefinitely, which is adverse to their interest. And Fani also got hit with a bar complaint from this nice Georgia man who's tired of her taxpayer dollars going to Fani's boyfriend. And so let's see what Jim Jordan says right out of the gates. He says, Fani, enough of this garbage already. We're Congress. Who do you think you are? From the Committee on the Judiciary, Jim Jordan sends this one to Big Fani Willis. He says, all right, dear Miss Willis, guess what? The Committee on the Judiciary is continuing its oversight over your corrupt DA's office in Fulton County. And we have concerns about your receipt and your use of federal grant funds that came from the DOJ. On February 2nd of this year, Big Fani, after several attempts to obtain your voluntary compliance with our oversight, the committee sent you a subpoena, which we read through here. Now, the subpoena compelled the production of two specific categories of documents, Fani. One, documents and communications referring or relating to Fulton County's receipt and use of federal funds. Hopefully, Nathan Wade knows what a receipt is now. Maybe he can educate Fani about this, because they had difficulty with that word back during the evidentiary hearing. And number two, Jim Jordan said we wanted documents and communications referring or relating to any allegations of the misuse of federal funds that came by your office. And we know that there's a whistleblower, okay, because Jim Jordan has confirmed that for us. He says there's a whistleblower that says there was actually misappropriation of funds. Now, on February 23rd, Fani, you responded to the committee's subpoena with a letter in which you smeared a former employee of yours who spoke out about your misuse of federal grant funds. We're not going to dignify your attacks on this brave whistleblower, Big Fani, and your continued attempts to distract from your own egregious conduct through misdirection and personal insults. You know, she's got a lot on her plate here dealing with her indictment of Nathan Wade. The allegations in the public realm about your misuse of federal grant funding are concerning, though, Fani, and the committee has an obligation to examine them. Jordan continues and says, we appreciate that you have produced a narrow set of documents in response to the subpoena, but your compliance with the subpoena to date is deficient. You haven't given us anything. Attached to your letter were various documents. I wonder if she put her calendar on there again, a number of which were previously produced to the committee that contained, among other things, 15 award letters from the DOJ's OJP and Office of Violence Against Women. What? Fani took all the stuff that she put on her refrigerator, that Nathan Wade put on her refrigerator, you know, with the magnets. Great job, honey. You got Saving Women in America award. Yay, good job. You got a Justice Against Bigots of America. Okay, great. Nice job, honey. Oh, you want another sticker? You want another star? Okay, here you go. Apparently she faxed those over. 15 award letters. She's like, I'm doing a great job. The DOJ losers said so, from their justice programs. Got it. Oh gosh, these people are so pathetic. Now, and approximately 27 screenshots of expense budget summaries that were available. So I guess she's saying, I use this money to get awards or to launch these programs or something. So whatever. She, slaps on a bunch of crap. She's like, it's just Congress. They're losers anyways. Sends it over to them. She's like, what are they going to do? Send me another letter? They did. Here's another one. So, however, you failed to produce any of the following categories of documents, says Jim Jordan. 1, all documents and communications referring or relating to any allegations of the misuse of those federal government monies. All documents or communications between you, among your office and the Justice Department, including its various components. All comms between your employees about the receipt of or use of federal government money. All documents that fall within the scope of the subpoena, including applications, proposals, grant agreements, financial management systems, internal controls, and other things. And all communications related to your office's grant performance, so when you get the money, and your progress reporting information. So Jim says, give it to all of us. Now, although additional materials are likely also responsive to the committee subpoena, as an accommodation, we will prioritize the production of the documents and the communications identified above. So forget about all the other stuff, just get us that. Now, your letter also requests that the committee, that's us, you said you want us to, quote, engage with the Justice Department to obtain responsive documents that you should have. You told us to go to them, but you should have it as part of our oversight, the committee has engaged with the DOJ about its administration of the federal grants, and the committee's separate request to the DOJ did not alleviate your legal obligation to comply with our subpoena. We're going to both sides. So in addition, Fani, in your letter, you noted a preliminary objection to our committee's subpoena on the grounds that the subpoena is overbroad, and you said it's unduly burdensome. Now, to the contrary, okay, the committee has exercised its authority with restraint. The subpoena seeks only 2 categories of documents, and the scope of its request covers only a limited time period, namely from January 1, 2020 to the present. And in addition, we also prioritize the stuff that we wanted, so we're accommodating you nicely. Now, while, Fani, you have indicated that additional documents may be forthcoming in response to our subpoena, the committee has yet to receive any additional documents in the 3 weeks, since your initial response. And so accordingly, the committee expects, Fani, that you will produce all responsive documents to the subpoena in the categories prioritized by us no later than midnight, March 28, 2024, 12 p.m. If you fail to do so, the committee will consider taking further action, such as invocation of contempt of Congress proceedings. If you think that will happen, maybe, who knows. Thank you for your attention to this matter. Sincerely, Jim Jordan, Chairman of the Judiciary Committee. You think Fani's going to respond by March 28th? She already got a subpoena. She flushed it down the toilet. You think she's going to respond? You think Congress is going to do anything about it? I don't think so. So we'll see what happens, but the threat is there, and maybe they will actually do something at some point in time. Not so sure that they will. But Fani is still in a bit of a predicament because this was an interesting X thread, and I wanted to plug this and shout out this gentleman at GSU Grinding. And apparently he's a criminal defense, tax law, con law, and litigation attorney, an adjunct professor, super collector, and he helps disabled vets and children. So here is a great thread that he posted, and I wanted to share this. He says, look, here's a quick explainer on why redoing the dismissed counts. So remember, Fani lost 6 counts because she couldn't even properly plead anything because she's incompetent. Why this is not going to be an easy and quick fix. And I know there were some concerns on yesterday's show that maybe McAfee was dismissing these as like he was gifting something to the defense because we know that he's not going to disqualify Fani. And this may be something that is a little bit more consequential and not as easy to remedy as some other people were saying it might be yesterday. So he says, here's the deal. Unlike federal courts and apparently some other states, a superseding indictment or another indictment, a second indictment, where you stay on the same timeline isn't really a thing, right? So like you start the case, we all know we've got speedy trial provisions and deadlines and all sorts of stuff. So can you issue a superseding indictment and just keep everything on the track, issue a second indictment? He says, well, a clever prosecutor might argue in an appropriate case for an expedited timeline because the first indictment is really the same as the second indictment, right? They're kind of the same. But that doesn't really work in a situation where the basis of the granted demur, the granting of the dismissal, was a lack of adequate notice, right? The reason those 6 charges went away is because we didn't know about what they were claiming was criminal. So if you refile those, you have to restart that whole timeline, right? Because now you have proper notice. So you should get the same amount of time that you've got in the other case, essentially. So that leaves 2 options, right? 1, take the entire case back to the grand jury. And 2, indict the dismissed counts correctly in a second and separate indictment. Now, 1 isn't going to happen because if you dismissed everything, right? Like that's crazy. Like they'd have to restart everything. The entire case would have to come back. You could do that in theory, but you wouldn't be back to trial for, he says 2027, maybe earlier than that, but maybe not. So option 2 is the only other option. The problem with option 2 is it reopens the ability to redo everything in that case, right? Now you're arguing about fresh deadlines in case number 2. That evidence that you don't want McAfee to consider in disqualification on the first case might come back up in the second case. So fair game in a new motion to disqualify in case number 2. Like do it again. Strategically, that'd be very dumb. Additionally, because the acts in case 2 are acts in furtherance of the RICO, and now you run into a double jeopardy problem. So in my opinion, there's no reason to open up that can of worms for some of the counts. So a couple of other technical, jeopardy questions. If you have dozens of overt acts in the second case and in the first case, what if you're acquitted in case 1? Then are you also acquitted in case 2? It's actually a lot more complicated than it sounds. So it's a very interesting thing, right? Fani might be stuck on those charges. And so that might support our table theory where the judge is just knocking out the legs of the table that we talked about yesterday. So another possibility and a great, interesting post from GSU Grinding on the X platform. But we also have this gentleman. He is just an average IT gentleman from, if there's anything average about IT, shout out to all of our IT friends out there. Guys save everything. But in other words, he's not a lawyer, right? He's not somebody who's like an interested party in this case, just a citizen who's sick and tired of Fani and her lover grifting off of his money. Let's hear what he says about his take on this case.
News since January, when all this broke, that a defense attorney found out that they were sleeping together, which she initially denied or didn't speak to. And then it came out that she did. And so I was watching that. I've watched a number of items there. I watched the Senate hearing, the Georgia Senate hearing that they had on the 6th of this month, and voraciously read a number of things because it just didn't sit well with me, what I was hearing. That I'm a taxpayer. My money was going to her boyfriend, and then they were going on trips together. So all the taxpayers of Fulton were funding exotic trips on cruises and to Napa and all this, and money was going from taxpayer to him and then back to Fani Willis.
At issue, it's not just money. You also talk about truthfulness. You talk about misconduct. You talk about a lawyer as a public official constituting threat of harm to clients. We know that recent text reveal, it looks like they had been together for what your bar complaint says booty calls. I mean, that is metadata.
Fani
as an
calls.
IT technician, you understand that. That's been brought out. And also you cite in your bar complaint these comments that she made at a church, her first public.
Fani calls in the House. So shout out to Georgia citizens who are holding their elected officials accountable. Shout out to that guy. It's, enough already. Like, it's your society. You want to live in a place where Fani grifts 700 grand off to go on Napa Valley and cruise extravaganzas? No, we don't. And so we, my friends, are going to continue to cover this. We are patiently waiting for Judge McAfee's ruling. It's going to drop by tomorrow. He said it's going to be coming in hot. So thank you for subscribing and joining us as we continue to cover the Georgia RICO case and all of the rest of the Trump trials. We're covering everything here, and it's going to be busy as things start to heat up. So thanks for subscribing. Thanks for checking out some of the stuff down in the description below. Watch Your Lodge, members only community at locals, and of course, robertgovea.com to grab the PDF if you want to read it. We'll see you back here on the next one.